IRA, how that's gonna affect your planning with Peter, okay? Or what you have to do. If you have a Roth IRA, what are the effects of that? Do I have to take some? A lot of times what people don't realize, and it's a slide I didn't put up there, some of you have to take required minimum distributions because you're over 70.5 or 72. There's another way that we could fund your pre-arrangements doing that. It's not uncommon that people do that as well. So we have lots of people throughout the North Shore that at least I do that with. So again, if you wanted to come in and get a review of your IRAs and 401ks and see where there might be some gaps that we can fill in these plans, fill out the card. At the end, we'll schedule a time for you to come see at least me or whomever. We can all meet together if that's something that's important to you. So that being said, I'm done on the insurance part. Does anyone have any more questions about insurance or any type of retirement plan that has to do with final expense or funeral planning? Yes, ma'am.
My friend had a prepaid funeral with a certain funeral director.
Yep.
And they closed. And they turned it over to Langone's in the North End, which was so inconvenient. So do you have it like an alternative if I do it with Caggiano?
So you would have, the person who had the pre-arrangement would have gotten a letter from the funeral home that closed. So I'm assuming it's Rapino's.
No,
No.
McGrath's.
McGrath's didn't close, they just moved across the street. Rapino's closed, McGrath's just moved their building. But anyways, by law, by state law, you have to, any funeral home that purchases another funeral home has to send a letter out saying that you become the custodian of those records and of that pre-arrangement. You have the right to transfer it to another funeral home at no penalty and no cost. And it's very, very common that that happens. But the thing is that like all of our trusts are held by a third party. So the funeral home does not hold the money. It's held by a financial institution. So that money is safe. The way the laws are, and I'll get into it when I talk about all the different ways that you can set it up. One is what Joe's talking about, insurance, but there are a couple of other different ways of funding it, dealing with spend downs and Medicaid and PACE and Mass Health and all that. But I'll get into that once we're done here.
So one other thing I want to address before I move on, and it's not on the slide. The reason why there's some stuff not on the slides because I've been told that people don't want to read slides, right? You lose them right away. But real quick, right? The most important reason why to choose any of the stuff, especially some of the stuff I'm talking about today, is because by planning, we can avoid probate, right? Life insurance avoids probate, it's beneficiable, so it will get passed on right away. Same thing, right? If for nothing else today, please make sure, whether you come to me or somebody else, go to a professional, review your beneficiaries, okay? Especially on your retirement accounts, those are non-probatable as well. So you don't want to get hit with a surprise, and you want to make sure that your assets go to the people you want them to go to. And it's a very commonly overlooked thing to review your beneficiary. I'll tell you a real quick story. New York educator, she became the superintendent of New York Public Schools. This is a long time ago. Never changed the beneficiary on her pension, and she left it as her mother. So when she ended up passing early in her 60s, over $1 million pension that didn't go to her husband and kids by law because she listed it was non-probatable. So again, just check your beneficiaries and make sure you review that stuff. So that being said,
Joe, can I just ask you, what
Yes.
happens if you have a will when you're talking about beneficiaries?
Yep.
Is it better to have a will or a trust? You know,
yeah, so that's a good question, right? If you want to control from beyond, it's better to have a trust, right? You don't necessarily need a will because the beneficiary will avoid that probate, right? So the will, what a will does, and I'll let them talk a little bit about it because I'm not an attorney, but the will basically would be in place, would name who the beneficiaries were, right? So if I didn't have an IRA or a 401k, for example, in my brokerage account where I own Amazon, right? My will would state where those assets go. But if it's inside an IRA, the IRA beneficiary would state where that goes. And if you wanted to do some other stuff, if you had estate planning issues, that's where a trust might come in, but I'll let Tim and Craig talk about that real quickly. So I'm all done with retirement plans and final expense insurance. Are there any other questions before I move on?
Can
Nope.
I just ask?
Yes.
So I'm not clear on this. If you have a will,
Yep.
do we have to still go through probate?
I believe not, but what I'm going to do now is I'm going
If you
to,
have a will, you have to go through probate.
I'm not an
You have to
attorney.
probate the will.
It's not a full process.
I'm not an attorney, but what I'm going to do now is from Callahan Magner Law Group, I'm going to have Tim Callahan come up and talk a little bit about the legal documents and the process you need as we go through the final planning stages in life. So again, thank you folks, I appreciate you
Thank
listening.
you.
Tim Callanan, I work at Callanan Magna Law Group. That's my partner, Craig Magner. I will get back to that question you just asked, very important. I just want to give you a little bit of a background about myself. Born and raised in Winthrop. I'm 43 years old. I lived up on the beach with my family. I've actually been on the police force since 2001. I've been a detective for a long time, and you might see my face, you might not. I really wasn't out and about in the crowds being a detective, but you probably know some of the cases that I led. Big tragedy in Winthrop, Bella Bond, Deer Island. I was the lead investigator for the department. I've moved on in a sense. I'm still with the Winthrop Police Department. I'm a sergeant. I supervise the night shifts. But I opened up a practice with Craig down Winthrop Center above the Chamber of Commerce building. We met in law school, clicked. He's a fireman, so police officer, fireman, good relationship we have, a lot of banter back and forth, but it's good. That's what we do for the town. I decided to get into estate planning in law school when my parents were talking. They were concerned. They went to go get an estate plan at a law firm, and they said the price was outrageous. And the reason they wanted to do it is because my father worked his butt off his whole life, and he said, I don't want my house to go to some nursing home if that time comes. I want it to go to my family, my kids. They deserve it. And he's absolutely right. There's no question about that. You don't work your whole life for something like that and then have somebody put a lien on it and take it away. So I said, don't do anything. Let me finish law school and I'll do it all for you, which we did. We came up with a great plan on how to do it. We both worked under other law firms that specialized in it, and we eventually went off on our own. And some of the things that I've seen, I'm gonna let Craig talk a lot about trusts. He'll dive into that aspect of it. But some of the most important things that come along with a will are a durable power of attorney, a healthcare power of attorney, a living will, HIPAA release forms. Quickly, a story, a real good friend of mine. He passed away, but when he got really, really sick, his family should have been by his bedside in the hospital. But he didn't have any of these documents set up, and they had to scramble around to get all his assets and everything in order before he passed away, and they missed a real opportunity to spend the final moments with him because of the chaos of not having these simple documents that a lot of people don't have and they don't even know about. It would have avoided a lot of heartache for the family. I push those on everybody. If you get in a will, I want you to get those other documents too. It's very important. If you're getting insurance, if you're doing any of these things, these simple documents are very important. The durable power of attorney. Basically, you give the right to somebody else to walk in your shoes in life. They can access everything you can access. So in a time, if you're incapacitated in the hospital and you need to withdraw funds to pay for something, they have a durable power of attorney document. They are acting as you with the full authority to do so, and they can take care of whatever you need to be taken care of very quickly so that they can spend their time with you. Very important. Yes?
Question. So when you do that, usually those things come up quickly depending on what's happened to your loved one, whether they're in the hospital, incapacitated. How do you go through that process? Do you have to go to court, or do you just simply see a lawyer and he takes care of that?
Well, if you don't have the document already lined up before, you have to go through the court process they have to order this to happen. But if you have that document, it's all ready to go. You don't need to go through the court. It bypasses that whole process. You can act for that person when you have this document. So in essence, I can issue a durable power of attorney for you where you name someone to act in your place, and that's good to go today. In 2 years from now, you're in a coma, you don't have to go to court. Look, I have this document, I am you. Avoid the court, avoid the headache, spend the time with you instead. That is a no-brainer. That I will push and push to make sure everybody gets that. It is such a help for your family in that time of need. It is an unbelievable burden. saw it with my own eyes, and I said, if I can help people not have to go through that, I will. And that is one of the things that accompanies a will. Now, your question about the will, it had to do with beneficiaries and avoiding probate, correct? Was that, am I on point? If you have a will in place and it names beneficiaries, it makes the process of probating so much easier. Basically, you take a death certificate, you take the will, you submit it to the court with all the documents, these were her wishes, this is what she wants, boom. Courts can be delayed, so it's not instantaneously, but it's basically sit and wait a couple months. They'll issue an order for personal representative, and then that person can act on your behalf.
Do they have to pay the probate tax if they have all this information?
So the tax man always wins, but that stuff typically comes out of the estate for whatever. So they will be acting not out of their own pocket. Everything will become the estate of so-and-so.
And that the estate won't have to pay the taxes?
The estate, depending on the situations, there's
Do you have over $5 million?
that,
What?
Do you have an estate worth over $5 million?
Oh, sure.
Then you're all set.
there's,
No, but if you don't have it?
there's a whole lot of situations, but typically it won't rise to that level.
So if your estate is more than $1 million in the state of Massachusetts or $5 million federally, you won't owe estate taxes because you'll fall under what's called the unified tax credit. Right? You can use your one-time exemption to give up to $5 million away without being taxed. So, or $1 million in Massachusetts. So anything above $1 million in Massachusetts will be taxed. Above $5 million
Well,
federally.
$1 million is not too much today, we can give you a house. and-
Well, if you have $1 million, I really hope you fill out one of those.
No, I'm saying, if you put all your assets together, your annuities,
Yep.
$1 million is not that much anymore.
Pretty much
A house
anybody
is
in
worth
the state of Mass that
600,000.
owns a house is gonna hit $1 million.
Excuse me?
Anybody in the state of Mass that owns a house is
Yeah.
pretty much gonna be right at that.
So what does that mean? I lost my.
That's where the estate planning comes in.
So this will segue into my introduction to Craig, where he's going to talk about, no, this is fantastic. You're just leading me down the line here. It's perfect. Setting up trusts. Very important. Anyway, please, go
I
ahead.
have a question.
Yes.
I have heard that living trust is better than a will. I don't know how that
Yep.
works.
So revocable living trusts.
Yeah, revocable, yeah.
Those, it's exactly what he's gonna be talking about in 2 seconds. He's gonna get you right there and dive into it. And there's a lot of different things out there that are available for your specific situation, but that is a very common thing to set up, and it's very beneficial for families. It can avoid probate and all these issues that he'll speak of. I did also want to comment, I talked about the durable power of attorney, and I'm trying to not be long-winded, but there's also something called a living will. In this document, it'll basically, you write out that my wish is, if I'm in a vegetative state and I have no chance of recovery, basically don't leave me on life support. Please.
Well, that's don't resuscitate, right?
No, but
It's
that-
not a
that's
do not
different.
resuscitate, it's, do not resuscitate's different.
It's different?
It is different. A do not resuscitate means if something happens to you, that you won't resuscitate. This says, something's already happened to me, I'm in a coma, I can't act for my own, and the doctor says there's absolutely no chance of recovering from this.
Pull it close.
This document says pull the plug, but it does more than that. It takes that obligation away from your loved one for making that decision. Because that's a lot of stress. Nobody wants to do that. Nobody wants to say, I can't believe I did that. Here's a document that I'm gonna say to my wife, if this happens to me, it's not your choice, this is my choice, do it. And that mentally takes, the mental aspect of this is huge. And it takes that away from them. It helps them in that time. So you can set up this document, and it'll help your loved ones make that decision for you. And it'll take that, that strain of being the one that actually made that call. It takes it away from them. It's pretty important. I always push that, but everybody's different. Some people want to be left on life support. Some, I don't know why, but some people do. It's your choice. But anyway, segue. My trust master, Craig Magner, Caggiano Magna Law Group, also a fireman, everybody's hero, you know, except for mine.
So like Tim said, my name is Craig, and I can answer one question real quick. The difference between a do not resuscitate and a living will, the do not resuscitate has to be done with a doctor. We can't do that for you. That has to be done between you and a doctor. And that just says if something happens to you immediately, somebody like me, a firefighter or EMT, can't come in and start doing chest compressions on you. The living will, like he said, is something that will start a conversation with you and your family so that when the time comes where you need to make a decision, that's already been decided. So those are just two, they operate completely differently. So like Tim was saying, a trust is a little bit more involved than a will. It's a little bit more upfront expense, but in the long run, it's much better protection for your family. It doesn't offer you a ton of asset protection, but it offers it for your kids. A trust plan will also come with a durable power of attorney, the living will, the healthcare proxy, all that stuff. We try to, like he was saying, the importance of those documents can't be understated. So we put those into any plan that we do. The biggest difference is with a will, you name beneficiaries in a will. You still have to use a probate court to get that certified. It doesn't go through a full probate process, but it still uses the court. And as they were saying with the insurance policies, whatever you name on that policy, you could say in a will, I want everything to go to my children. But if that policy with a beneficiary says something different, it's going by policy. So with a will, it's very good to have it in place. It lets the court know your wishes, but the trust plan is a lot more robust. So with a trust, it's almost like an alter ego. So you live on, and you control that trust beyond, years beyond when you die. So what that does, it avoids probate altogether. You don't go to, nothing in that trust goes to a probate court. And what we'll typically do is put a pour-over will in there. So we say anything that we overlooked or missed that you own is gonna go into this trust and go by the terms of the trust. So the big thing with a living trust is we can protect assets and help with the tax thresholds. So Massachusetts, as much as it's great to live here, their tax threshold is terrible. It's at $1 million. The federal level, like he was saying, is $5 million. It's actually a little bit more than that right now. It's 11.5. So between you and your husband, you could save $23 million worth of assets at the federal level. Massachusetts still hits you at $1 million. So what the trust will allow us to do is when the first spouse passes away, we take $1 million of assets and put them into a credit shelter trust. So those get passed down to your wife and kids without any tax on them. Anything over that $1 million limit goes to your wife or your husband. Anything left to your spouse goes tax-free at that day. At the second spouse's death, we take another $1 million out and send it to the kids tax-free. So now you've protected $2 million. The rest of it, unfortunately, is going to get taxed, and there's not much you can do about that.
Craig, one second.
Yeah, absolutely.
So one thing you can do, with especially using a credit shelter trust, or what used to be called, you're right, I was wrong.
Marital trust, credit shelter.
Yeah, the old AB trust, right, I don't think they have those anymore, but, once you go above that 2 million threshold, utilizing, the credits that he's talking about, you can also, buy what's called the second to die policy, right? So now, like he said, you have $9 million or so, right? After you take the first $2 million out, you have $9 million left, okay? And once you get above the 11, if you didn't want your kids to have to pay taxes, what you would do is while you're alive, buy insurance or have that trust buy insurance, okay? And then at the death, life insurance proceeds are tax-free. So now we can take the proceeds to pay the tax bill that is now due on your estate, and your kids now get the money and don't have to pay taxes on it. So they would get the full benefit of everything you see, utilizing trust.
Sounds very
Oh, Gene Yawkey, Peter wanted me to remind everyone that that's how the Yankees passed along all their assets, being that tomorrow is opening day for the Red Sox.
So Gene Yawkey had probably $150 million in her estate. Her estate bought a $350 million life insurance policy. So they liquidated all of her cash assets, bought a $350 million life insurance policy, and then when she died, there were 10, 12 different beneficiaries on that policy. So that's how the rich stay rich. So getting back to what he was saying about the second to die, that's how you're able to protect that from taxes.
It sounds very complicated.
No,
It is.
It's not.
But if you get the right people, like, you know,
What if you only have, what, you keep talking about spouses, what if we're all widows?
You can do the same, right, Craig? I mean, you
Yeah,
guys-
so there's something called portability where you can use your spouse's unused exemption. Unfortunately, Massachusetts doesn't have that. So if you're widowed and you haven't already taken advantage of your spouse's 1 million exemption, unfortunately, Mass, there's not much you can do. You're gonna be able to give a million sheltered, but that's it. Federally, say you didn't use any of their 11 million exemption, you can take that over to you and you'll be able to pass down 22 million.
I don't think we're in that category.
I know you're not, but I'm just saying how portability works.
you
So
sure?
it would be nice if you were.
Question.
Yeah.
So what if you only have $20,000 and you're, what do you have to offer for someone who's retired and they need to protect that money for their own living?
Yeah.
They could live till they're 99, or maybe to pass down a couple thousand to their kids if there's anything left over. I mean, I know it's a small amount, but there's a lot of people that
No,
have a
there's a-
smaller
There's a lot
amount.
you can do. So the revocable life trust is the way to go because you use that, even though you're putting everything in trust, that's you while you're alive. You use it as you use it now. It's based on your social security number. You don't notice any difference in ownership. And then when those trust assets get passed down to your kids, they're protected. They're not a marital asset. So as you guys all know, divorce rates are crazy right now. Anything you leave to your kids in that trust will go to your grandkids. Even if they get married and divorced, the divorcing spouse isn't going to be able to touch that asset. So that's how it's protected down. And it's protected from creditors and everything else, depending on the language that we use. So if you have a child that isn't good with money and they have creditors banging on their door, whatever you leave in that trust, as long as they keep it in that trust, we can protect it from creditors, certain creditors. With the smaller estates, the trust is fine. It doesn't, outside of the initial setup, running a trust doesn't really add any expense to your day-to-day. So whatever you put in there can still be protected going down, whether it's $1,000 or $1 million. It's still protected. It protects the house, the cars, whatever you put into it. If you wanted to do very minimal estate planning, I would say you could do a will with all those other documents, and then you take care of your bank accounts with like pay on death designations or a joint account, stuff like that. Those joint designations, when you pass away, they will avoid probate because it automatically passes to the joint account holder. Or you could do a pay on death, which would avoid probate. So when you pass away, it goes to the named beneficiary of that account. Those are simple methods. If you don't have a lot, I would recommend against them because you don't have the asset protection. Once those assets pass to whoever you're leaving them to, they're open to creditors because they get it right then and there. Anything you leave in a will that goes to your kids, if your kids have creditors, the creditors are going to be able to come in and go after it. If it's in a trust, it's protected to a much greater degree.
Would you say that again?
So if you leave stuff in a will to your kids, once it becomes effective and they take it, that's their asset.
All right.
So if they have creditors, child support or anything, if they defaulted on a loan and a bank is coming after them, those creditors can go after that, whatever you left them. If you leave it in a will, and depending on the language of the will, those assets can be protected. So those creditors can't get it. Certain creditors will, taxman, the government, child support, those creditors are always going to be able to get
That
things.
has to be specifically signaled out in the will?
Yeah, and it's very common language to be able to protect it.
Spindthrift clause.
Yeah. I know that's a lot of information, it's very technical, but that's why we do it. I know everybody has their own personal situations. So if anybody wants to come talk to us at any time, we give you our cards, we're available, we do free consultations too. And like I said, if you guys want to meet up all of us at the same time, we're more than happy to do that. If you guys have any specific questions I can answer right now, I'm more than happy to. If not, we'll turn the floor over.
Mr. Peter Caggiano, no introduction needed.
So as Tim said, my name is Peter Caggiano. Some of you I do know, some of you I don't know. Just a little background on me. I run the Caggiano Funeral Home here in Winthrop with my dad. My dad's pretty much retired now. I'm a third generation funeral director, so my grandfather, my father, and then myself, and my son's in the business too. We started back in 1927 in East Boston. We came to Winthrop in the 40s. So we're coming up on 100 years in business in 2027. So it's quite a feat for a family-operated business. I'm probably the last guy that you want to talk to. When you really think about it, I'm the last guy you want to talk to. But the problem that we see in our industry is we get the panic phone call. When it comes to pre-arranging a funeral, we get the panic phone call. So 95% of the time when we make a pre-arrangement, it's because the family has to do a spend down. You all familiar with what a spend down is? In order to get on Medicaid, Mass Health, and PACE, you can't have any money, can't have any assets. Meaning you can't have cash, you can't have a cash value life insurance policy. And I know Joe had mentioned something about life insurance, but that particular life insurance wouldn't be considered an asset of the estate. A whole life policy from a regular John Hancock, Prudential, and so on is considered an asset because it has cash value. You can go after that cash value. So the problem that we see is that it's the panic phone call, we need the paperwork today, blah, 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 the whole bit. What we want to avoid is that. We want, estate planning, will planning, trust planning, and all that, so that you have everything in order, so that it is not that rush. Because more often than not, it's not you that's coming in to make that arrangement with me, it's one of your children, or your husband, or whoever, because you're already somewhere that's why they're doing this. Now, the state allows for 100 days. So you can get 100 days in a nursing facility, the state will pay for. After 100 days, you have to either become a private pay or a Mass Health Medicare PACE. So that, usually, I get the phone call on the 99th day.
How about long-term insurance?
If you have long-term insurance, that's another factor.
Does that kick in after the 100 days?
It should. It should.
It would be stated on, your policy should have a specific elimination period, right? And how many, and it would be elimination period and average daily, this is a bunch of letters, daily, things that you can do daily, right? You have to hit 3 out of 6 that you can't do your daily routine, and it would be stated inside that policy. So each policy is different. I know that, in the early part of this century, long-term care was very popular. What we found was companies went out of business because they didn't know how to underwrite for it, right? So what we do have now, if you don't have long-term care, it's not too late. There are a lot of very popular annuity plans that allow for long-term care, okay? Some life insurance policies have long-term care carve-outs, but to answer your question it's an elimination period. And then from there, the long-term care would pay based on your daily payout, right? So you would have had to do a check way before you were put into a situation, whether you wanted 90 days, $90 a day, $110 a day, $200 a day. And I will tell you here in another presentation that I've done here before, in Massachusetts, the average cost, we're below New York, higher than California, is about $118,000 a year if you need to get someplace else. So again, part of the other stuff that we didn't kind of hammer on today, but maybe we'll all come back another time and talk about, is what Peter's talking about now, and planning how to obtain Medicaid, how to protect those assets that if you do have to go into a nursing home or some sort of hospice. There are some other alternatives. But sorry, that was a little long-winded. To answer your question, it's elimination period.
So,
I'm sorry.
no, that's fine. So, with the state of Massachusetts, there is a 7-year look back. So they can look back at all your financials over a 7-year period. So if you gave me $1 today, 5 years from now, you had to go into a nursing home, they want to know where that dollar went. Do you understand that? You know what I mean? So there's a 7-year look back. So the thing is when you get to a certain age, you need to start doing things with your money. And that's why we're all here. Because you all worked hard, we've all either retired or were left certain things by family members and whatnot, and you want to protect those things. The problem that we see all the time is that the nursing homes drain. Because like Joe said, you're looking at over 100,000, depending upon the nursing home that you go to. Some nursing homes are less expensive, and that's the care that you're going to get. Some are more expensive. Some are $10,000 a month, $15,000 a month for nursing home care. So those are things that you have to factor in. Either it's getting back to, like I said, the 95% people that come in, it's very rare that I get somebody who had just retired, came in, sat down, wants to get everything out of the way. It is very, very rare. In my 40-something years of working with my dad, I think I've done it once in 40-something years. And somebody, the day they retired, they came in, they sat down with me, they did them and their wife. And they wanted to get, and they're both still alive. Now, the thing is that there are ways of funding a prearrangement. There are 3 different ways of funding a prearrangement. One is what they call a one-time payment, meaning you pick out your funeral, my funeral's $10,000, you give me a $10,000 check, we put that in trust. That money is irrevocable, it can never be touched until somebody passes away. The interest from that money will offset any inflationary costs. There's also purchasing either a one-time payment life insurance policy, or how Joe explained it, you could pay every month or every quarter or whatnot. The only problem with the life insurance aspect of it is that it's not cash guaranteed with the funeral home. Meaning if you have a $10,000 life insurance policy right now and you die 20 years from now and the dividends and interest didn't offshoot inflationary costs, your family might have to come up with money at the end. So funeral homes very, very rarely guarantee life insurance. Now, it's very, very rare that I would ask a family for more money. Very, very rare, because we pretty much guarantee all of our policies and our trusts. The one thing that funeral homes will not guarantee are what they call cash advances. And what cash advances are non-funeral home related items. Those are items such as the cemetery, the church, newspaper notices, things like that. Things that we have no control over. You understand what I mean by that? Now, getting back to if you should have like a small life insurance policy that you've had for years, that'll affect your eligibility for Medicaid, PACE, and Mass Health. You can make the funeral home the beneficiary and the irrevocable owner of that policy. That policy no longer becomes an asset of your estate. Or you can do what they call, you make the funeral home a beneficiary of a part of the policy. So let's say you have a $100,000 policy, and the funeral home is a contingent beneficiary of that policy. Well, what happens is the funeral home will file a claim for what's owed at the time of death, and then whatever money's left over goes to the first, second, and third beneficiaries of those policies. So you might have a policy that has 4 different beneficiaries on it.
So do you need a lawyer?
For that, no. No, all it is a piece of paper from your insurance company. And then we do all the paperwork for you. And the one beneficial thing about sitting down with any of us is it doesn't cost you any money. It doesn't cost you any money. You can sit down with me for hours, I can give you all the information in the world, I don't charge you anything.
Here we're handsome.
So that's the importance, that you're getting free information. Even if you came to my office, sat down with me at my office, and there's no charge for that. Even if you don't pre-arrange with me, there's still no charge for that. You know, it's basic free information, so you might as well take the information. You know, it's good to have several different options when it comes to things like this. You know, you might not like what I have to say, but you want a little bit more information, so you go talk to another funeral director and things like that. So, you know, everybody, you know, in the funeral industry, everybody has their own family funeral director. You know, why they went there, and you know, so on and so forth. So it's not, I'm not here to talk you out of doing that. I'm here to give you as much information as possible. The lawyers brought up a lot of good points. You should always, always, always refer to a lawyer when it comes to any decisions based on your trust. There are lawyers out there, and I do have a lawyer that is what they call an elder lawyer that specializes in the elder law. And what this girl does is that she helps you with the whole PACE process and the Medicare process and things like that. If anyone's ever been in the meat market, she's a friend of Sandra's in the meat market. That's how I got this girl. She's handled a lot of different people for me. She's very, very inexpensive. But you know, there's a series of different people that you need to talk to. You know, just like Tim and his partner and Joe and myself, these are all things that'll help you out in the long term. Now, we had talked about it in the beginning. Let's just say for some reason you came to me, you handed me money, I took the money and I put it into trust. Then all of a sudden, we sold or we went out of business or something happened. Your money is still protected because your money is held by a third party. And that third party, that money is put into Citibank. And I don't think Citibank's going anywhere. So, and that's the thing, same thing with insurance. The one thing that we've seen over the span of me being in the business is that a lot of these companies change names. But the insurance is always there. They just get bought out by another insurance company. So it's very, very rare. It's only happened once in my whole career that an insurance company got taken over by the comptroller of the state. This happened up in New Hampshire, so.
Peter, can I ask you a question?
Yep.
Say I came in and I arranged my whole funeral, and then I changed my mind.
Yep.
What happens then? Like, just say,
If you came in, you did your whole funeral, and then for some reason down the line, you didn't like me anymore.
no, not that.
No, I'm just using that as an
That's
example.
possible.
Right, it's possible, yeah. You can transfer it without cost. Now, inside that yellow folder I gave you,
Uh-huh.
there's a white sheet, and in that white sheet are all the state laws that's required on funeral trusts.
Okay.
You can cancel at any time. There's what they call a cooling off period, like with any contract, there's a cooling off period. There is no penalty. And even after the cooling off penalty period, there's still no penalty. So all we would do is, we would get a letter from you saying that you wanted to transfer it to funeral home ABCD, and then we just transfer it to them.
But what happens if I didn't want to transfer? What happens if I just wanted it?
If it's irrevocable, you can't transfer it. So there are two ways of setting up, revocable and irrevocable. If it's irrevocable, that's it. There is a way of doing it, but it's gonna cost you money. So, we advise anybody that's doing that, probably 99% of the contracts that I write for prearrangements are irrevocable, because we're protecting that money. And that's the whole idea, is protecting that, so down the line, if someone should have to go into a long-term care facility, that money's not considered an asset anymore. And there's no,
And they couldn't touch it.
there's no 7-year look back on that either. So if you gave me the money today, and you had to go in a nursing home 5 years from now, they don't use that money as an asset, because it's in a irrevocable funeral trust.
Even if it was like within the 7 year.
It doesn't matter, because it's in a funeral trust. All other things go into that category, but, not funeral trusts.
All right, thank you.
What about the 5-year look
I
back?
thought it was
That-
five
It
years.
actually is a 5-year look
No,
back.
they're changing 7.
Oh, they did?
It's 7, they go back 7 now. I'm going through it with my in-laws right now, so they're going back 7.
But they change it all the time, don't
They move it around, they do move it around, but again, Tim, and you can tell me if I'm wrong, but this is just, my father-in-law is going through it right now, and the lawyer that's on it is saying that it's 7.
They fight that stuff harder than anything else.
Yeah, every irrevocable trust, it's because you're protecting such a valuable asset. The majority of them is people put their homes in them. And like I told my father, you gotta put that in there before that 5-year period goes by, or else they can attach something to it and take from it. So, last 5 years, Dad, and then you're okay with that house. The irrevocable part of that is what protects it. So that's a very important thing. You have to really do that as soon as possible, if, like, transferring a house into that.
And the thing with that is you keep hearing irrevocable. When it's irrevocable, and a lot of people are hesitant to do this, because you're giving up control. And that's the thing, is you're giving up that control, and you're trusting us to basically be your defender. So you have to put a lot of trust into lawyers and financial advisors and funeral directors and this and that. And especially a funeral director. A funeral director is the caretaker of somebody that passed away. Those people can no longer care for themselves anymore. So it's our job is to protect them from the time they pass away until the final disposition, whether it's burial, cremation, or things like that. It's our job to protect that person as well as the family's interest. Well, it's the same thing that these guys are doing. These guys are protecting your interest, but in a different kind of way,
So I have a question. So say a living estate, you change over all your assets to the person, so the parent or kid can stay in the house, but they end up that they can't take the nursing home. Am I explaining it right? Like, in other words, they're still living in their home, something like what you said about your father. but it's called a living estate,
It's a life estate.
life estate.
Yeah, so what you do is you would put the house in an irrevocable trust and retain a life estate, which means you live in that house for the remainder of your life, and then at that point, it goes by way of trust.
So if I.
Just retaining that life estate will not open it up to Medicaid scrutiny, but
Okay,
it's still the look back period.
so I could stay where I'm living,
Yep.
even though I have nobody living at the time with me, and
Yep.
then whoever I designate.
They would get it.
And how
after.
many years is that, like 5, 7? Is that still 7?
Yeah, if they change to 7, it's a 7, it's the same look back period. The big thing with what we do with irrevocable trust is a little bit different. If you put a house in an irrevocable trust, you can actually get it back, but you have to get, say you name your kids as beneficiaries, they would have to allow it.
The only reason, because I've heard horror stories, people have done that,
Yeah.
and then sometimes
It's all based on the family dynamic, and it's different to everybody. If you 100% trust your kids, there's not a huge threat of putting it in an irrevocable trust. If you say change your mind 5 years later, you want to sell the house and move to Florida, you can't just do it, but your kids can give you permission to do it. If you wanted to make major improvements to the house, you would need your kids' permission to do that too. That's with the irrevocable. There's other things you can do with the, revocable and stuff, but, it all depends. You gotta weigh your family dynamic versus what you wanna protect and kind of see where you're comfortable.
I don't want to step on Peter anymore, this is his spotlight time, but with the irrevocable trust, what you do is you deed your house. So everybody that owns a house, the deed is in their name. You deed that trust to you deed that house to the trust. So now the trust owns the house. And what clause that I always put on an irrevocable trust on that deed is the life estate. So my parents deeded their house in trust with me as the trustee, irrevocably. So eventually, when that look back period is over, it's not theirs anymore. And we joke saying, well, now that it's ours, what if we want to kick you out of the house?
This is it.
Well, the life estate, which, me and my sister were joking, but I do it for everybody, is you do put a life estate clause in that deed that says subject to a life estate in your name, which means no matter how much me and my sister end up hating our parents, which is obviously a lie, but if we did, we can't do anything because they have a life estate in that property, and upon their death, the death of the second one, then we can freely do with that property what we want.
That's a really good point. I
Yeah.
hope people are listening to that.
That's, so you do trust your kids, but there is a clause in the deed, and that actual clause that's big in the lawsuits. They try to fight it because there is a life estate clause. Well, it's really still their property. In the courts, the highest court, the Supreme Judicial Court in Massachusetts, over and over again now, it was called the Daly case, they said life estates in a deed is okay. That property is still protected from the big creditors, so,
Thank you. Yeah.
sorry, Peter.
No, I'm pretty much done. Do you have any questions?
Yes, sorry.
So can you make clauses to fit each individual circumstances?
Depends, it
If
depends
they're
what the
legal.
circumstance, yes.
Like, so,
If they're legal, yeah.
yeah, like a clause is part of the law? I'm just trying to figure out.
So clauses are part of legal arguments all the time. So depending on what your needs are, and that's over a more like a sit down with us. We find out exactly what you're looking at. Oh, we have something that'll help you. Like a simple homestead. I don't know if people know what a homestead is, or if they have it on their house, automatically protects you from $500,000 worth of liability. If you run somebody over and you're at fault, you were texting, and they want to sue you for everything they have, they can't take your house. For a simple $35 document that you file with the state, they can't take your house. And they protect your house up to $500,000. If you own $1 million home, they can come after you for the additional $5. But then there's also, if you're a senior citizen and you're married to another senior citizen, you can double that protection amount. There's all sorts of little different things that we will tailor to your specific scenario. But, without going around the room and doing it, that's what the consultation is with everybody. we can say, oh, by the way, we know of this that can help you as well, we know of this that can help you, and we design everything around you specifically. There's no general plan that everybody can just say, hey, can I get Plan A or Plan B when it comes to the legal aspect. We definitely form things around you. Big questionnaire, a lot of questions, we want to make sure you're protected, but, you know, that's why it's important.
So what Tim's saying is that everything that we all do is tailored around your needs. We're not gonna tell you, you need this, you need this, you need this. You tell us what you want, and then we're able to do our job, and that's what we're supposed to do. You know, in my business, everybody would wanna have a full traditional funeral with a wake, a funeral, and go to the cemetery. It doesn't work like that. You know, everybody has different wants, everybody has different needs, and everybody has a different financial standpoint. So, you know, and that's what we all are here for, is to help you, whether you have money, whether you don't have money, that's what our jobs are.
Can you change your plans? Like say, when you made your plan, you wanted like 2 days.
Yep.
Now I'm getting older, I want 2 days, I want 4 hours.
Yep.
Can I change the plan?
Yep.
Do I get a rebate?
I mean, a refund?
Refund.
No, not a refund, because,
All right, so here's the thing,
I mean, if you make.
And there's a wink, there's gonna be a wink in this, there's gonna be a wink in there. Just a little flutter I have in my eye.
Oh yeah, this is WCAT?
Yeah, I have a wink, I have a flutter in my eye. So, here's the thing, if it is an irrevocable trust, and the money is in that trust, and you did a spend down, if you were to change the arrangements, because it's happened to us, that a son, and I won't mention names, but a son kept moving his father around. His father was in a nursing home. 100 days was just about to expire. Oh my God, something's wrong with my dad, he's gotta go to the hospital. Sent his dad to the hospital. The 100 days started all over again. He did it for 3 years. 3 years. Think of how many times he had to take his father out of a nursing home. 3 years.
Don't they get suspicious?
Nope. No, because
No question
here's the thing. He didn't go back to the same nursing home. So as long as you don't go back to the same nursing home, the 100 days start all over again. Well, the son was a lawyer. He knew.
He knew what he was doing.
So we had already had a prearrangement on the son. I mean, on the father, I apologize, on the father. And when the father died, the son came in and he's like, you know what, we're just gonna meet at church, we're gonna change the casket, blah, blah, blah. So there was about $3,500 left in the trust. So the son goes, Peter, can you just mail me a check? I'm like, absolutely, I'll send him a check. And I sent him a check in the estate of his father's name. Because what happens to the check? You gotta get it probated. So now he calls me up,
Tell me that again?
that money has to be probated because you did a spend down.
Because it's in the father's name.
Exactly, so the son, I could keep you here for all day to tell you stories about what the son did to his father,
Yeah.
but I'm using it as an example of if you did a spend down, that money was spent down in order to protect you so you could get on Medicaid, pay some MS health. So if I were to give you that money back, it would be considered fraud. It's welfare fraud. And a lot of funeral directors have gotten into trouble for it.
No kidding.
They actually waived it during COVID. So during COVID, we had a lot of people that passed away that were prearranged in nursing homes that passed away of COVID. And during COVID, we couldn't have any services. We could only have 10 people in the funeral home. We couldn't go to church. It was, 1 hour in the funeral home, 10 people at a time to the cemetery. Well, people that had paid us for a full service funeral had money due back to them. The state waived it during that time that we were able to give that money back to the families.
Not the estate of?
Huh? Not to the estate of, no. No, we could give it back to the family because the family didn't change the services. The state mandates changed the services. So they were able to get that money back. But we try not to play with that money
But
because
now that COVID is over, what are the rules?
technically you're supposed to give it back to the estate of. Yeah. And the one thing I tell all my families when they're doing a spend down, and this is the problem, is I'll get a family to come in and they'll do a spend down and like, Peter, I gotta get rid of all this money. And they'll be like, I'll give them a price like, oh, I don't wanna spend that much. And what I'm gonna say is gonna sound kind of crude, but it's true. You're either gonna give it to me, or you're gonna give it to the state.
Right.
You're not saving any money. There's one thing, and you guys should write this down, just so you know what this means. So they'll allow for you to do a irrevocable trust with a funeral home, but they'll also let you do what's called an FBO account. So an FBO account is for the benefit of. You can put up to $1,500 in that account. And you can use that for a collation after the funeral, if you're gonna take people to lunch, gravestone, flowers, and things like that, because they don't allow you to put certain things in the funeral trust. So in the last 2 years, they've taken out, we used to always put flowers in there. Now they kick it back, they say, no, you can't put flowers in there anymore. So now they came up with this FBO account that you can set up on your own, it's got nothing to do with the funeral home, and that money's protected. So it's an additional $1,500 that you could save on top of the actual funeral.
And how do you get this extra $1,500 benefit?
It's not a benefit, it's your money. You take your $1,500 and put it in the account. And what they call it's for the benefit of, like Mary Smith. You bring that money, it's like opening up a CD in the bank. But if you were gonna do something like that, I advise do not use Bank of America. Bank of America is the worst bank when it comes to FBO accounts. I had a family, they had an FBO account in Bank of America, person died in February. They didn't pay us until August. So, you know, Bank of America, well, it was East Boston Savings, but I know Rockland Trust does it now. There are certain banks that do it, certain banks don't get involved in it, so.
I do it.
There's so much to absorb.
Yeah, for what? Thank you.
So that being said, right, and for everyone's time, we were promised an hour, we went a little bit over, right? So, like Tim had mentioned earlier, and Peter has said, everyone's situation is unique, right? So, two last things. Like we had mentioned, everyone has the opportunity to get a free consultation. Today was to be purely educational and to give back to the community, right? We all live here, we all have to go to the marketplace together, so we're not here, there's no sales presentation, there's no pitch. Other than that, you know, if you heard something, and you want some more information, fill out the card. But let's start with what a no means. If you came today and you're happy with what you got and there's no need, you have no need to meet with any one of us, don't fill out the card. It's okay. No is a perfectly acceptable answer. It's all right. Like we said, we're here to give back. However, if you did want some more information and you think that one or all of us have some tools and products that may be able to help you out and maybe demystify some stuff that you weren't sure about, fill out the orange card. Put a time that's applicable for you, best time, and we'll try, and whether you want to meet with, who you want to meet with, or all of us. We'll find a time that's convenient for all of us together, and I can promise you that we'll give you at least 55 minutes of time to try to go over and answer as many questions. Now, filling out that card doesn't mean that you're going to be a client of one of ours. We may not be a good fit for exactly your situation, and you may not be a good fit for what our practices look like. But that being said, we will meet with you, and if we do think that we can work together, then we'll decide together what the next steps are, okay? But remember, no is a perfectly acceptable answer here. We do appreciate your time, and we thank all of you ladies for coming in today. And you can always call us direct too. You all have our cards and our direct numbers and stuff like that, so, feel free to call and ask a question or stop by, and be more than willing to give you as much information as possible.